Hello, everyone, and welcome back to Conundrum Conversations. Today, we are so excited to announce our guest, who's a very inspiring person, Kimo Gandall, with us. Kimo is a JD candidate at Harvard Law School, the senior editor at the Harvard Journal of Law and Public Policy, and a professional registered parliamentarian. He is also the founder of Fortuna Insights, a company that leverages data to provide strategic solutions for businesses. Kimo's journey in law, policy, as well as business, it offers us a very unique perspective on the intersection of these very fields. So we are so excited to hear his thoughts. So welcome, Kimo, and thank you so much for being here with us.
Yes, thank you for that was a great introduction.
Thank you. Now, Kimo, starting off, we asked this question to all of our guests. What inspired you to pursue a career in law? Was there a particular defining moment or experience?
No, I mean, law is the way you go about fixing structural problems, right? So I was in speech and debate throughout my high school career. I studied law during undergrad. I was interested in machine learning and AI algorithms before ChatGPT made it cool, right? I kind of been involved in this sphere for a long time. And so I was just always interested in how to fix things. And it so happens that the best way to fix things on a societal level is through law, whether that be private law, which is what I'm going to advocate today, or public.
Perfect. Talking about law school, you're in law school right now. How has your experience at Harvard Law been like so far? Was there any particular experience that you found the most impactful in terms of strengthening your legal skills and knowledge?
Yeah, no, I love Harvard Law. It is filled with some of the smartest people I've ever met, much smarter than me, in fact. Harvard truly teaches you humility, which is a trait many Harvard Law students do not come into the school with. I think one of the defining moments for me was during my 1L civil procedure class. And Professor Greiner, he was my professor then, love the guy, love how his classes. It's very much like an algorithm, right? And so he was describing the role of the lawyer. And a lot of professors see the lawyer in a much more romantic sphere, right? They see him as upholding the law and the only barrier between the devil and man, if you cite back to Roper, right? In some of the early English contemporary literature. What Griner described it as is a gladiator. And that's really what the way you should, most people in common parlance see the attorney. They don't see the attorney as this valiant knight standing up for social progressive values, right? They see it as somebody arguing on their behalf to get them the result they need. And that's kind of how I approach law from a MLAI perspective, which is getting the clients what they need, not trying to write the next legal treatise. And so that inspired me a lot to kind of pursue this field of private law, which is much more pragmatic and arguably has larger social impacts.
Wow, that was a very interesting take. And I'm definitely going to internalize that idea just like you did. I believe law school is very hectic, is what I've been told, right? So, can you give an advice to students who are just starting law school now? And what would that be?
You mean just starting law school?
Yes.
Oh, well, as I'm sure they've already discovered in 1L, it's a lot of caffeine and late nights. And the fact is, 1Ls are academically hazed. If you go to any school and you ask them the curriculum, you cannot balance the curriculum properly. You cannot do all the readings. You cannot, it's just not possible. That being stated, I found it totally doable and possible, but in terms of actually doing well. It's less about academically internalizing every doctrine and more about performing on the exams. So really, you need to practice exams, do tons of practices, start outlining very early, and just understand that what law school is a system. It's trying to create you as a lawyer. It's not trying to educate the next generation of academics. Now, Harvard does a good job of having that in 2L and 3L, but 1L is really about teaching you the core black letter doctrines of law and then teaching you how to think like a lawyer, which basically just boils down to understanding both critical substantive content, although you probably won't remember most of it, and being able to think critically on every side of the debate.
Perfect. That is great advice. Now, Kima, we know that you're the senior editor at Harvard Journal of Law and Public Policy. Could you tell us what kind of articles and issues do you find the most compelling to publish and why?
Yeah, I mean, I'm not interested in publishing the next textualist issue. Then again, I'm not on the committee that decides that. There are people higher up on the ladder that decide the actual publication issues. I've always been most of the articles, though, I try to get involved in have to do with the common good and actually understanding law as a function of natural principles that we are attempting to enumerate and expound on in society and treat people fairly. So I'm very interested in articles that have actual practical implications. There are way too many wannabe theorists out there now, way too many people who have their next hot take on some doctrine, right? I'm interested in how do we go out and actually change the world. And that's driven a lot of the research I've done and written for. One of the articles I published myself recently in JLPP had to do with parliamentary procedure in Congress. And it has a very explicit command at the end, which is no, you cannot have proxy voting. And it tells you what you can go and do. And that's way better than, the next edgy take on common good constitutionalism or originalism or textualism or whatever you might have it be, economic theory. I'm interested in those theories insofar, and just to be clear, I think there's still a place for theory. Professor Adrian Vermeil is an absolute genius in his method of articulating and changing the discourse around originalism and textualism. I even have some respect for Judge Posner. He does not like AI technology much, I think because he doesn't understand it. But I mean, he has a great theory on economics and law. And there's a place for theory, but there are way too many wannabe theory articles that are not useful and nobody reads and will never be practical. So less theory, more practice.
Perfect. And now that you mentioned that, how do you think legal journals like Harvard Journal of Law and Public Policy they influence real-world legal and policy debates?
Yeah, so I mean, anything at Harvard is going to influence real debates just because it's at Harvard and people like citing to it. GLPP is very popular, especially in the conservative movement. It is a conservative law journal. So it does influence a lot of doctrinal debates, which I guess that's the argument for theory, right? Is that it's actually influencing those debates, but I'd much rather them talk about practice. Mostly as a personal preference. But yeah, I mean, there's lots of articles we publish that have to do with actual practice. I mean, I think one of the edgiest pieces we published was even if we're moving outside of AI, there's a good article coming out from Jack Kefauver on Judge AI, but there was a piece on like, would the founders have approved of blasphemy laws, right? Like, so there's like some very interesting articles embedded there that I think get overlooked, but are often very integral to originalist dialogue on the bench. So even if like the common person on LinkedIn hasn't read through the articles, I think it does influence the academic sphere.
Perfect. Now I see that you've shown a lot of interest in the intersection of the disciplines of law and technology. So tell us what legal challenges in tech policy do you think are the most pressing today, and how do you believe young legal professionals could perhaps solve or navigate through these challenges?
Yeah, so as CEO of Fortuna Insights, I've seen a lot of technological change over the last few years. I was laughed at 1L when I started talking about AI and ML and their implementations in law, and lawyers just excuse it off the hand, right? Or they're like, oh, it didn't do what I wanted one time. Not like any associates ever do that. So, we're going to excuse the entire technological base. So I think there's resistance. Part of the resistance is it's going to replace a lot of them. Uh, yeah, you can talk about, oh, it's going to enhance them or whatever, but that's going to cut that out to the bottom 20%. And technological progress always does that. Now, it might enhance litigation, but you should really, I think more people need to think about why they're going to law school. A lot of people just go to law school because it's the next checklist item, you're a political scientist, everything like that. But law does not make a lot of people happy, realistically. So if you're not going to, I mean, there are some great schools outside the T14. I seriously contemplated ASU and Notre Dame. Both of those are beautiful schools. I personally love them. Really, ASU shocked me with how nice it was and how great it was and some of their reception there. So I loved that. But you should really think about why you want to do it. I really think a lot of people think they're just going to get the next big paycheck. But honestly, for the amount of time and cost you have to put in, if you're just going in to get another big paycheck in big law, just get a tech degree and go work as like IT for a Fortune 500 company.
That's very, very true. And Kivo, could you, staying on the same topic, could you tell us if you believe that there are any upcoming technologies that the legal system is unprepared for?
Yeah, I mean, Arbitrust, the technology we just published, clearly a lot of people are unprepared for. It's going to replace human arbitrators. It's an end-to-end arbitration process. And really, it's just because a lot of lawyers have not conceived of a possible technology beyond chatbots, right? It's inconceivable that you can string these bots together, use hybrid formats with ML models, voting ensembles, and be able to cast accurate descriptions, right? If you go look at the comments section, Brian Potts, one of our partners from Hutch Blackwell, that posted on this, there's hundreds of comments there, and a lot of them are like, well, AI can't make decisions, right? It can't characterize somebody's testimony. Of course, ML can do that. Deception algorithms have been around since the early 2000s. That's actually some of the least compelling technology, but it's just because the legal industry's never seen them in conjunction with LLMs. So people are completely unprepared, especially normal lawyers, for the sort of competition that arbitration will put up. Now, if they were smart, they would join on the bandwagon. They would be getting ready to represent clients in front of the AI judge, not fight it and refuse. And I actually think this is a great opportunity for lawyers to bring in massive amounts of revenue for their firms, right? With AI technology, you can engage in things like ex ante queries, which is a fancy way of saying you can predict results ahead of time. You can use algorithms to give your clients actually as a quantitative analysis of your case, what you could be expected to lose, the time of the case, and actually give clients a much better informed decision making criteria for pursuing litigation, as opposed to right now where the lawyer just tells you, it's gonna depend, I'll shoot you a budget, billables, things like that. Again, I think lawyers are hesitant to adopt new technology because they're just little c conservative. They don't want to embrace a lot of these challenges or I've even had a couple lawyers tell me that my technology emotionally threatens them, right? Because it threatens to replace a livelihood for them. Instead of resisting technological advancements, they should join us. They could find a real source of revenue from it. Uh, and embrace upcoming technology, embrace change, embrace social utility. Don't resist it.
Wow, that was a very unique perspective, and now it has changed my way of viewing the modern technology as well. I believe it's so pertinent now than ever to understand how we can use this technology to our benefit instead of seeing it as a threat. So, thank you so much for putting that in such perfect words. Now, you also briefly mentioned the intersection of your legal expertise and knowledge with your work at Fortuna Insights. So, could you elaborate further on that?
Yeah. So what Fortuna has built, Arbitrus, for example, is a series of large language models and machine learning algorithms that help make decisions, whether that's at the briefing stage, the discovery stage, motions in between there, and the final decision making authority. And so what Arbitrus will do that is so revolutionary is cut out the human arbitrator. It'll actually industrialize the process. What lawyers are is essentially a guild. So in the Middle Ages, Marx talks about this, right? If you want to get into the classical neoliberal theories and socialist theories, is before capitalism, there were guilds of professionals, and those professionals were able to control their industry through internal dialogue and norms and laws that applied only to those professionals. But there was no systematic way of providing that benefit. What capitalism does and what it's successfully doing with law as well is revolutionizing the way people engage in the means of production. So the means of production for law as a service is briefs, it's legal arguments. What we're able to do is now actually industrialize that entire process and provide people the majority of people, right? Capitalism has created enormous prosperity for people. In the same way, law has been one of those industries that has held people back because they're filled with this guild of overpaid attorneys. And so much like you had with the carpet maker, the blacksmith, right? All of those who are producing individual products at a much more inefficient pace, we will be able to completely industrialize that end-to-end process. And that means people submitting the briefs. You're going to have AI lawyers that do that. You're going to have arguments. You're going to have AI lawyers who help with that. All directed by humans, of course, but they're going to be managers. They're going to be the ones on the production lines. And then at the very end, what we're doing that is revolutionary is replacing the human decision maker, the arbitrator, with an AI bot, much more accurate, much more systemically conceivable, and it saves tens of thousands of dollars. It's 1/10 of the cost of a normal complex commercial dispute. And so what you're going to be able to give is people a lot more value, a lot more bang for their buck. And with a product like this, you can affect way more people. So on my side, it scales brilliantly, right? Yes, we're making less money per case, but now we can handle thousands and thousands of cases on a single workflow instead of individually having to assign it to each person in the guild, which is essentially how law works right now. So this is a different method of thinking. What AI law threatens the contemporary industry with, and what we have is we're industrializing justice. And people might view it as dystopian but think about the average person. Most people have no access to justice right now. Do you have $1 million to go blow on a crack litigation team if the United States of America wants to prosecute you? Of course not. Or even if a large corporation wants to sue you, you don't have the capital for that. We are providing you an opportunity to get your say, to have justice. Yes, it is industrialized justice, but some justice sure beats no justice.
Wow, perfect. That was fascinating to know. Knowing that something like this can transform the entire field in obviously in a better way. So thank you so much for letting us know that in enlightening us with that. Um, I think you're doing an amazing job. Um, moving forward, Kimo, one particular aspect of your profile that really piqued my interest was that you are a professional registered parliamentarian, correct? What motivated you to become one, and how has your deep knowledge of parliamentary law complemented your work in legal research or policy analysis, or even the different roles that you've undertaken?
Yeah, great question. So what a parliamentarian does is they apply the rules of order. Now, in a business, that would be like in your bylaws, you say, "Oh, will Robert's Rules of Order will control the business conduct for this meeting," or something like that. It could be other parliamentary hand manuals. So my job is, if you ever go into a meeting and you want to make a motion, have you ever done that before? Like you move to do something, you move to recess or something like that. That's where my specialty was. This is perfect for arbitrus and other processes I've been involved in because I know how to make an easy to understand and streamlined process. So it's really helped me write out the arbitrus processes, conceive of how to write them out, and then organize them.
Great. And according to my knowledge, Kimo, I know that many law students and even practicing attorneys, they aren't well versed in the parliamentary procedure. So do you think that this should be a bigger part of the legal education? And if so, why?
Yeah, I absolutely think so. Knowing Robert's rules and how institutions actually function is incredibly important to getting what your client wants. I think a lot of law school is not tailored to practicality. I mean, there's not really a transactional part of law school, which is just as important for a day-to-day life. Law school is mostly tailored towards litigation practice. And so that's probably why there's not more of it. But yeah, I mean, you're not taught any of it in law school. So yes, I think there should definitely be courses on parliamentary procedure.
Also, what we want to know, what are your future aspirations in law, particularly in the areas you've been actively involved in, such as policy or technology and administrative law?
Yeah, my aspirations. I want to create the world's first private and widely accessible and distributed court system. So I want to completely revolutionize the way people go about resolving disputes in the private sphere. And essentially, I'm going to be a replacement for public courts with a lot of commercial disputes. So that's my ambition. It is very lofty and it is ambitious. I think it's also financially feasible. It's one that makes the most economic sense. You can have lit financiers coming in and financing these cases because they're much more predictable on the arbitrage platform. There's just every reason to do it and no reason not to.
Wow, and we wish you the best of luck in doing so.
Thank you.
Lastly, you know, is there any general advice that you would like to give to aspiring legal professionals and motivated high school students like myself who are interested in the legal field?
Sure, sure. So first off, you plan to go to law school, you need to focus on your GPA and LSAT. If you're below 170, take it again. This is just, even if you don't want to go to T14, it will put you in a great negotiating position to negotiate a much higher scholarship. So do that. Um, let's see, get a good GPA. Really, a lot of this, people don't like to talk about this in law school. They want to tell you, oh, your softs are important, but they're not as important as that GPA LSAT. That is of course, those are necessary, not sufficient. You need to have strong softs, but most of us are pretty ambitious and already have them. The law admission officers don't have a lot of time to read every single app. I mean, they do read them, especially at the top schools. But they need to see you have sufficient scores to be able to thrive at Harvard. So get a good LSAT.
Perfect. That was very realistic advice, which I think many people do need to hear. So, thank you so much, Kimo, for sharing your expertise. It is always an honor to learn from such accomplished and incredible individuals like yourself. And I learned a lot, and I'm sure my audience did too. Once again, thank you so much for being here. And to my audience, thank you so much for listening and tune in more for more insightful conversations. Until next time.